SwayamPrabha. Digital India. Educated India.
Welcome students to the class of Transfer of Property Act, and this is the last lecture in this subject, that is lecture number 20. Myself Dr. Amarendra Kumar Ajit from Faculty of Law, University of Delhi. In last lecture I am going to discuss about the mutual transfers. Okay, mutual transfer of ownership, which is formally it is called exchanges. Okay. So, I am going to discuss about this and what are the provisions under Transfer of Property Act. This is a unique kind of transfer. That means both the party are seller and both the parties are purchaser. Okay. You might not have seen this kind of transfer in case of sale, mortgage, lease, actionable claim transfer, gift. Here both the parties are seller and both the parties are purchaser. Okay. And this exchanges may apply for both movable property as well as immovable property. Okay. So, you might have heard about the barter system, one of the oldest system of transfer, in which people were used to transfer something for something. That means things were used to be transferred. Okay. That means you want to purchase thing A, then you will give thing B to A and A will give certain things to B. So, this was the barter system. So, this exchanges here it will apply both in case of movable as well as immovable cases. Okay. Barter system was more frequently in case of movable property, and this had been oldest system of transfer itself. So, once it has been drafted in the transfer rules and regulation has been drafted in the form of Transfer of Property Act. So, the exchanges has been also kept under this and got certain places within the Transfer of Property Act. So, now I am going to discuss exchanges. What I will discuss in this, first of all, I will go with the definition part of exchange, then certain examples of exchange, then a status of oral exchange, then essential feature of exchange, then rights of party deprived of exchange material, then rights and liabilities of party, because here both the parties are seller and both the parties are purchaser. Okay. And then exchange of money. So, these 7 topics I am going to cover and I will try to summarize it also at the end. So, first come to section 118, which talks about exchange itself, that what is exchange. According to section 118 of Transfer of Property Act, exchange means when two persons mutually transfer the ownership of one thing for the ownership of another, neither thing nor both things being money only, the transaction is called exchange. Okay. So, prima facie, first of all I will try to briefly discuss this definition here itself, then I will discuss through essential part of exchange in detail. So, what it says here first, that when two persons mutually transfer, that means A and B are two persons who have property X and Y respectively. Okay. So, A is the owner of property X and Y is the B is the owner of property Y. So, here A, two persons mutually transfer, it is a mutual transfer of the ownership with respect to these property. So, first of all, in exchange, this is the transfer of ownership. Now, you can see that in how many transfer there is a transfer of ownership. Okay. So, you will see that sale is the one category where there is a complete transfer of ownership. Gift is another kind of transfer where there is complete transfer of ownership. And third is exchange, where there is complete transfer of ownership. Okay. So, these are the kinds of transfer where there is a complete transfer of ownership. So, here A is going to transfer X to Mr. B with full ownership, B will transfer to A with full ownership of Y. Okay. So, A will have Y and B will have X with full ownership. Okay. And neither things nor both things. What it is saying, neither, that means not a single one or not the both things being money only. So, there is no exchange of money. If any party is using money in this, suppose X is A is giving for Y any amount of money, then it will not remain exchange. Or B is going to give any amount of money for X, even then in that case it will not remain exchange. So, what it will be? Money is the only consideration in sale. Okay. In sale there cannot be anything else. We have already read under section 54 that money is the only consideration in sale which is called as price. Okay. So, here money will not be in the picture. Money is not going to be a part from any side because it is a mutual transfer. So, not from any side it will be. Okay. So, money is not the subject matter for consideration. Here one consideration is one consideration that one goods is the consideration for another goods. Okay. One property is consideration for the other property. Whether it is movable property, whether it is immovable property, it is completely immaterial. So, the meaning of exchange is that in exchange there is a transfer of ownership of one thing for the ownership of some other thing. Transfer of ownership for consideration of money is called sale, I have already explained you, whereas without consideration it is a gift. Yes, without consideration it is gift. Suppose X is going to be given by B, going to be given by A to B, and B has given nothing, no property, no money. So, it will be a kind of gift, and I have also discussed about the gift in the previous lecture. Okay. So, this will become gift. So, where the money is the only consideration, then it is sale, and where nothing is consideration, then it is gift. Therefore, where a property is changed for another property, that is called exchange. So, one property will come as consideration for the another property, and there will be change of ownership, exchange of property. So, it fall under the category of exchange. Okay. Now, further it says that an exchange includes a barter of goods for movable property. So, barter will come under this. Okay. Barter system is for movable property. So, one movable property is exchanged with the other movable property. So, earlier it was the common mode of sale also. Okay. Common mode of sale also, that means exchange in the villages, that means barter system was completely prevalent even up to 15-20 years before. Okay. That means one goods you can give and another goods you can take. Just you will give the rice, you will give the wheat, and they will give you oil, salt, whatever the daily needs requirement they were used to give. Presently also in some area, remote area, this barter system still exists, especially in the case of villages. Okay. So, in that way, that is the consideration, but that will fall under the category of exchange. Okay. So, here it says that an exchange includes a barter of goods or movable property for movable property. These provisions are applicable to exchanges for both movable and immovable, just like sale, because we have seen in sale movable or immovable both are under this. It says that movable and immovable. So, in case of exchange, it is movable as well as immovable, but in case of sale there is a one difference, that movable goods are governed through the Sale of Goods Act, immovable things are governed through the Transfer of Property Act. But here in case of exchange, whether it is movable or immovable property, if it is the subject matter of exchange, then both will be governed through Transfer of Property Act. So, where the ownership of a thing is transferred for money and not considered at exchange but a sale, okay, and in the same way, but where along with the ownership of property some money is also given in addition to it, this also include exchange. This is important part. Okay, this is important part, that means from both side there will be exchange of this property. But it further says that if from one side there is in addition to property there is some transfer of money also. That means not only money, but property plus money to compensate the price of the another property, then in that case it will be treated as exchange, it will be not a invalid exchange. Okay, and it will not convert into sale. That means there is already property and some part is going to be paid in the form of money. The whole part will be paid into the form of money, then it will go into the sale, but only some part is going to be paid in the form of money, then it will go into the exchange. Okay. Example of this through I am going to give this, that where there is some part of consideration in the form of money. So, it says that where one of the two properties which are to be exchanged exceeds the other in value, the transaction would be an exchange even if some money is paid by the owner of the property in addition to the property. Okay. So, what is the example here? If a person exchanges his house, A is going to sell his house, okay, worth of 2000 rupees with a field of worth 1500. Okay. B is going to deliver a field, okay, and A is going to give his house. So, this is the transfer of exchange of immovable property, transfer of immovable property. But because property is going to be exchanged with the another property, so it is falling under the category of exchange. So, suppose the value of house is 2000 rupees, okay, and the value of this field is 1500 rupees. So, now it is field is going to A and house is going to B. Okay. So, what here B? B got 2000 rupees value in the form of house, whereas A is getting only 1500 in form of field. So, who is here in loss, A or B? Certainly B is taking more money and A is in loss, because it is not equal in price. Okay. So, he is getting 1500 and he is getting 2000. That means, he will have to get 500 more from Mr. B. Okay. So, what he will do? Now, the B will give this field plus 500 rupees more, okay, he can give certain immovable property also, or he can give cash also. So, when he is going to give into the form of money, that means immovable property plus money, then the whole transaction will fall under the category of exchange, not under the sale. But suppose if B would have given directly 2000 rupees to A, then it would have been a case of sale. And if A would have been given his house to B without any consideration, so then it would have been a kind of gift. Okay. So, always remember that where money is a only part with other properties, movable or immovable property, then it will be a form of exchange. Okay. It will be a form of exchange, but it is also requirement that from other side it is coming into the form of property only. Okay. Then oral exchange not permissible. Okay. Oral exchange is not allowed at all. What he says that oral exchange is not permissible in view of the amendment of section 49 of the Registration Act. Okay. Section 49 of the Registration Act, which came in 1929, which by inserting section 49 of the Registration Act, the word has been added or by any provision of the Transfer of Property Act, has made it clear that the document of which the registration is necessary under Transfer of Property Act, but not under the Registration Act, fall within the scope of section 49 of the Registration Act. Okay. That means earlier it was not necessary, but now registration in the case of this, when there is a requirement of through oral exchange. Okay. So, through oral exchange there is no possibility of this, oral exchange is not permissible. Okay. That means written instrument is sine qua non for exchange. Okay, exchange. Then question here is there any this kind of limitations with respect to rupees and all? So, to what extent? Because just like in the case of sale, we have seen that. Okay, if you remember the provision of sale. So, what was the necessary criteria? That if sale of immovable property is of 100 rupees or more, then registration was must. Registration was must. Okay. So, if here it has been said that if not registered, oral exchange is not permissible. If not registered, they are not admissible as evidence. Okay. When they are not registered, what is not registered? Exchange deed. Okay. Exchange instrument, because instrument is something different, that means between parties, whereas registration is additional criteria. Additional criteria. What is the essential here is this? Essential is this one. Essential is this one. That means there cannot be oral transfer. So, there will be always written transfer. But written transfer is not required to be registered. Okay, not required to be registered. So, what is saying that if not registered, they are not admissible, instruments are not admissible as evidence of any transaction affecting any immovable property. That means, if you are dealing with exchange and within exchange subject matters are immovable property, then this written agreement is very important part. Without written agreement, this exchange cannot happen. Okay. That means void ab initio, oral exchange is not allowed. Then question here is whether this written agreement should be registered or not. Law is saying that not required, but if not required in law, but it will create problem in case of proving the title, because it is the change of ownership, and when the ownership is going to be changed and it is not registered, then it will create problem. So, it is saying that in that case, what is saying that not admissible as evidence and affecting any immovable property comprised therein and do not affect any such immovable property. Transaction by exchange which is required to be effected through registered instrument is if it was to affect any immovable property worth 100 rupees or more. Transaction by exchange which required to be effected through registered instrument is if it was to affect any immovable property worth 100 or more. That means, the same procedure or same law as it is in sale is applicable to the exchange also. That means, if the price of immovable property, the value not price, value of the immovable property is 100 or more, and in that case there is an exchange of that immovable property, then there will be registration is required. If it is less than 100 rupees, registration is not required. Okay, registration is not required, but cannot be produced as evidence. Then essential feature, okay, certain essential feature of exchange. First is transfer of ownership. Exchange involves transfer of ownership in some existing property. This is also important. That means, property is here, ownership properties is here in existence. In existence means future property cannot be the subject matter of exchange. Okay. And when it is about immovable property, then that property, whether it is movable or immovable, must be in existence at the time of transfer, this exchange. That means, in existence means what? It must be under the ownership of the transferor, okay, exchanger, because both here are exchanger, whether it is one side or another side. So, property in existence means that there is existence of ownership. Sometime it may happen that okay, there may be the future property that you are going to purchase it. So, physically the whether it is movable or immovable property, they are in existence, but there is no ownership, just like in the case of right of co-sharer in Hindu family. Okay. So, co-sharer rights is there, claim is there, but unless and until there is no partition in that, okay, property cannot be segregated. So, which part is coming to whom? It is not, they are the co-sharer of that. So, in future it may be the right of the co-sharer. So, that is property is in existence, but ownership is not there. Okay. Just they are mere co-sharer in that. So, once the share will be divided and their name will come against them, then they will be they will have exact this property with value and all, then it is in existence. So, co-sharer are not that is they have no ownership with respect to a specific property, unless and until there is partition of that. Okay. So, they may be the joint owner, but it is not a divided property. So, which property is going to whom, it is not clear. So, in that case we can say it is a kind of future property which is going to come, which is presently in existence. So, right in that property is going to be transferred. So, ownership here what we are going to see, ownership. So, ownership over the property must be there. Okay. Then in transfer of ownership, absolute interest of owner is transfer. So, I have given you already example of that, that in case of sale, gift and this exchange, there is complete transfer of ownership. Wherever there is a complete transfer of ownership, then whole right of owner will go. That means, owner have number of rights. I have discussed in the sale that ownership is a bundle of right. Okay. So, in this bundle of right, when you are transferring it, we are exchanging it, whole right will go to the another side. Okay. And when you are taking the property of another in exchange, then whole right of the another side owner will come towards your side. So, transfer of ownership is one of the must criteria. Okay. Then properties need not be immovable. That is also very important, that in this case property is not required that it should be only immovable property. That means, exchange is possible for movable as well as immovable. Okay. Immovable property may be exchanged with movable property or vice versa. That means, it is also not condition precedent that immovable property will be exchanged through immovable property or movable property will be exchanged only through the movable property. That is not the case. Immovable property can be transferred with the immovable property can be exchanged with the movable property, and movable property can be exchanged with the immovable property. Okay. So, these are the possibility of transfer. Suppose there was earlier there was practice that some land or some house, that means immovable property or pond or well, they were used to be transferred in lieu of certain number of cattle. Okay. So, cattle is movable property, whereas pond is immovable property, and this kind of the exchange was used to happen. So, this may fall under the category of exchange here. Then characteristic features of exchange, third is exchange includes barter. Exchange includes barter means what? One movable property for another movable property, barter system. Okay. Is allowed under this. Exchange allows barter system, and this is the very one of the oldest system. I told in the beginning itself, this is the oldest one. So, these sections also protect the barter system, that you can exchange movable property with another movable property, and this complete transfer of ownership in movable property will be there. Okay. So, transfer of ownership in some movable property in consideration of transfer of ownership another movable property is known as barter. So, there will be complete ownership transfer even in the barter system, no problem in that. Then mode of transfer. What are the mode of transfer of exchange? So, according to section 118, provide that the transfer of property in completion of an exchange can be made only in the matter prescribed for the transfer of property by sale. Okay. Transfer of property by sale. That means, the rule of exchange will be the rule of sale will be the rule of exchange for the purpose of mode of transfer. That means, that we are going to follow that if there is a exchange of movable property, then it can be only through the process of delivery of possession. But in case of immovable property and price is more than 100, then there will be through instrument and registration, where there is only immovable and less than 100, then only through instrument, and only movable, then only through instrument. Why? Because this exchange, in exchange, oral transfer is not allowed. Oral transfer is not allowed. So, you should read sale provisions with keeping in the mind that there is no oral transfer. Whereas, in case of sale, if you will go through this, then it is permissible that in case of this movable property, there will be transfer even without the instrument, even without the instrument. Here it is not permissible. Instrument is necessity in any case, whether movable or immovable. Registration is optional. In one case where the immovable property is less than 100, registration is must, just like sale where it is 100 or more than 100. So, you will combine section 118 as well as 54 about the mode of transfer. Okay. Then characteristic feature of exchange, another is say that both formalities of section 54 to be compiled with here for the mode of exchange. Where the both property are movable, exchange may be affected only by delivery of possession without registration. Okay, without registration, it is saying not without instrument, keep in mind, not without instrument, because only you are delivering the possession, just only exchange of possession. What is the meaning of it? When there is a only exchange of possession, meaning thereby this is the oral arrangement. Okay. Oral arrangement, oral exchange is not allowed. Where the properties are immovable and value is less than 100, registration is optional. Okay, registration is optional, not the instrument is optional. That keep in mind, instrument is always necessity. Then, but in case of value of immovable property which is more than 100, registration is compulsory. So, better that we can prepare here, suppose movable property and immovable property. Okay. Movable property, immovable property. I am just this movable property may be of any price, not 100 or below 100. Okay. But in case immovable property, we can categorize below 100 and 100 plus or above. Okay, above. Then in this case, in all these instrument, that means written agreement, written agreement, written agreement, written agreement necessary. In all, written agreement is necessary. Okay. But here and this case, if this is the column of written agreement, this is the column of registration, registration. So, in this case, here it was compulsory written agreement, but registration is not necessary. Okay. Here immovable property, here in case of immovable property, written agreement is necessity even below the 100 rupees, here it is optional. Okay. And if immovable property, then it is compulsory. So, in that case you will see that here in case of movable property, written agreement is compulsory, registration is not compulsory. In case of immovable property below 100 rupees, written agreement is compulsory, but registration is optional. Where immovable property is 100 and above, written agreement is necessity and registration is compulsory. Registration is compulsory. Okay. These now what is the difference between these? Written agreement is between parties. Okay. But here registration is in government offices. That is the different. Okay. That means here both the party will go and they will register this instrument, this written agreement that we did it, and these are the term and condition, and accordingly we are registering it. So, now I think it should be very clear for the mode of exchange, that where there is a requirement of written agreement where there is a requirement of registration. Okay. And also try to remember that what is the difference between instrument and registration. That instrument only governs the term and condition, then what has been done in exchanges, then that instrument is going to be registered in government offices. Then it is necessary that deed of exchange must be a valid contract. Deed of exchange must be a valid contract, that is written agreement must be a valid contract, where a valid contract means all elements of valid contract will come. That means major, person must be major, then after person must be of sound mind, then there must be free consent, all these things will come in this. So, where the deed was executed to compromise criminal proceedings between the parties, it was held that since the object of the contract of exchange was unlawful, the contract and therefore the exchange was void. So, if your contract is not valid contract, if the essential of contract itself is not valid, where there was a misrepresentation of fact, there was some coercion, undue influence, misrepresentation, okay, when the subject matter is frustrated. So, in all these cases, if contract is not possible or if it is contract is going under the void category, invalid, then this will be not treated as exchange. Okay. So, it must be a valid contract. So, in this Sri Hari Jaina versus Khetram Mohan Jaina, it is the case of Odisha High Court. Odisha High Court very clearly said that because whatever the agreement in this case, that is exchange agreement or exchange deed has been created, that was unlawful because it was for the compromising the criminal proceeding. So, in that case it is not possible that it will be treated as deed of exchange. The next is in case of partition of joint Hindu family property. The court held that once the partition is effected, whether by way of family arrangement or by deed of partition, okay, whatever way the mode, that means by the family arrangement, by the mutual agreement and all, or by the deed of partition, there is severance of jointness of properties. Severance of jointness of properties. Two brothers thereafter exchange property which were held by them separately. Okay. So, I gave you example earlier also that in case of co-sharer, okay, they are the sharer of the property, they are the owner, joint owner also, but because the property is not divided, property is not certain, then what you will exchange, that creates the problem. So, here the one step further it is example that there was partition, okay, and partition may be the partition by the act of the parties or through the deed, okay, through family arrangement or through deed, whatever it may be. But once the partition has effected, that means the property has been segregated, okay, property has been segregated. So, every co-partner is knowing about that what is their portion, what is their portion, okay, and now they are trying to exchange it. Generally, it's happened in joint family, Hindu family, at the time of partition, the partition has happened, then someone is not satisfied or to some extent they want to exchange it. Okay. So, court here he said that severance of jointness, after severance of jointness of property, that means once the partition has been actuated, executed, then the two brothers thereafter exchange the property which were held by them separately. That suppose take the example here, F, there is transfer between F and C, okay. So, C has given to F and F has given to C, exchange of immovable property. The property is being worth more than 100 in value. By these exchange, movable property is more than 100 in value, then they could have exchanged them only by a registered instrument. Okay, this is a very, very important part, that after partition in Hindu joint family, if any person is exchanging their own share or own property with their own brother or sister, okay, then that must be registered. That must be registered. Sometimes it may happen that if the family arrangement and mere oral things has been gone, then there is a no problem. Problem will come when there is a deed, partition deed. The partition deed means what? That a family arrangement may be the oral arrangement that, okay, this portion we are dividing it, later on we will go for the documentation and deed. Then there is no problem. But suppose the division has happened and the deed has been prepared. That means in written form the division has occurred. Problem will start from that place only. Okay. Because now division is on paper. So, whenever you will try to prove your share before the court, then court will ask which property, okay, which property. And if you are going to change the exchange the property, then that exchange would not be mentioned in that deed. Okay. So, what is the possibility? Possibility is that if you want to exchange the property, then better that create a new deed, okay, new deed, and otherwise if the deed is going to remain same, then the property must be registered, okay. Property must be registered because it is more than 100. So, these are the possibilities. So, if something is happening after 5 or 10 years, then it is not possible, okay, because there is a already deed, everyone is enjoying their own share, later on they want to create any kind of exchange, that will create problem here, okay. Then right of party deprived of things received in exchange, 119, right of party deprived, because here both are seller and both are purchaser. So, the best thing is that you will see in this that both will have both kinds of right and duties. In section 119, which provides that for a contingency in which one of the parties of the exchange is deprived of the property received by him due to some defect in the title of the other party. Okay. If any other party to an exchange or any person claiming under him is deprived of the thing received by him in exchange by reason of any defect in the title of the property, such other party is liable to him or any other person claiming under him, legal heir, successor, whoever may be, for the loss caused by such defect or for the return of the things transferred at the option of the person so deprived, if things is still in possession of such other party or his legal representative or transferee from him without consideration. Okay. So, now try to understand this provision. A and B, they are exchanger, okay, and same I will take example X and Y are their properties. Okay. So, X went to B, Y came to A, then exchange has done, deed has been also done. Later on what B is realizing that X property is defective property, X property is defective property. So, when X property is defective, then what the remedy will be vested with B. Okay. So, here it is saying that if any party to exchange or person claiming him may be legal representative, authorized agent or whatever it may be, any person may be, okay, those who are entitled to claim under him, they can say that what they can say that is deprived of the things received by him by exchange of this region and this property title, such other party is liable, such other party, that means here property is of X. So, X is the property of A. So, A will be liable for loss caused to such defect. That means, due to defect in X, whatever damage has been caused to Mr. B, that will be the responsibility of Mr. A, the loss caused by such defect. Okay. For the return of the things for the return of the thing transfer at option of the person so deprived. That means, B will have option to return the things to Mr. A. So, okay, if the things is still in the possession of other party, if B had possession of that, then it said that for the return of the things transfer at the option of person so deprived. Person deprived here is Mr. B. If things is still in the possession of other party or his legal representative or transferee from him without consideration. Okay. Then it says that this Y must be returned to B. Y property must be returned to B, or if A has already given to C, who is the taking this property without consideration, So, whether the property Y is with A or it is property Y is with C, this property, B's property, B will ask that your title is defective, then keep your title and return my property. Or if A will say that no, I have transferred to C, but that transfer was without consideration, it was not a sale in that case, or it is in the form of gift, then B will have right to claim that property from C. But if C is purchased that property with due consideration, then B will have a right only to claim compensation, and A will have duty to compensate, okay, for whatever loss there is. So, right of the party deprived of the things, that is, here A is seller, like seller, because this chapter govern these sections of exchange more or less govern through like sell itself. So, A is a seller, B is purchaser for X good, Y is seller, A is purchaser for Y goods, okay, and vice versa. So, the liability and right is also towards parties subject to condition of the goods and their vice versa. Okay. So, in that way it works. So, more or less it has been the right of the person who had got the detrimental interest in that property, that will have that kind of the right against the other person in exchange. Further it says that, however, this remedy is subject to the contrary intentions appearing in the term of exchange. The parties may have agreed to the contrary. In the such case, this covenant cannot be implied. Okay. This is, however, this remedy is subject to contrary intention. Contrary intention means what? It is, I have said that contrary intention is that if the B had knowledge that, okay, B had knowledge that there is some defect in X, and in that agreement it has been said that, okay, being knowledge of this defect, he is going to purchase it. That means, contract to contrary, this is the part. Remedy subject to contrary intention appearing in the term of exchange. Okay. Appearing in the term of exchange, that means must be mentioned in the deed of exchange itself. The parties may have agreed to the contrary. Contrary means the rule is that B will not purchase it because it is a defective title, but B is saying that, okay, we are friend, no problem, we will bear this loss, take this property and give that property, and indeed it has been mentioned that knowing these things I am purchasing it or I am exchanging it. In that case, such a case, this covenant not be implied, this covenant this will not imply. Okay. So, these are the possibility. The party suffering loss due to the defective title of other party to the exchange has been given two remedies under this section. Okay. What are the two remedies? That when the sufferer party will have two remedy under this section. What are those? He can recover the compensation of the loss suffered by him, or he can take back the things transferred by him. So, I have already given you remedy this, that B will have right here to claim loss directly from A. Okay. If what are the satisfaction of B, B will know. Okay. But B is entitled to claim this loss. B cannot, or B can directly ask that my property should be returned back. Okay. These are two rights. B's property will be not returned back only in one condition, that if A has transferred B property to third person with consideration, then B will be only entitled for compensation, not for the property. So, right of party deprived of the things received in exchange, okay, under 119 says that however, the second remedy is available only in three situations. Second remedy is what? He can take back the things transferred by him. This will be only applicable when, where the property is still in the possession of the other party, where this property is still within the possession of A, then only B is entitled to take back, otherwise not. Then in the possession of his legal representative, that means not only A, but if the property of B is in the possession of, that is Y property is in the possession of A's or A's legal representative, or a transferee from him without consideration. So, a transferee from him without consideration, who will be? That means generally without consideration is gift, or it has been kept for some time, that okay, transfer has been kept, that take care of it without any consideration. Okay. So, that is possible. Caretaker, if there is a agent is there. So, in that case, C is C having the property without consideration, then B will have a right. So, B will have right only in three conditions. First, A must be in the possession of B's property, A legal representative or A legal representative, legal heirs are within the possession of B's property, or A has transferred third person here C without any consideration, then only B can ask for the title, return of the property. Okay. Then rights and liabilities of the party. So, rights of liabilities of the parties are just like it is in case of sale. Okay. All the rights of liabilities, because here I told you A and B both are seller, A is seller to B, B is seller to A is buyer. A is buyer of the property of B and B is the buyer of property of C. B is the buyer of property of A. So, whatever the rights and duties of buyer, right and duties of buyer plus seller will apply to A. It will vary according to the subject matter against whom. In same way, right and duties of buyer plus seller will apply here. It will vary according to the according to the subject matter and parties. Okay, and parties. So, these rights and duties is just like seller and buyer, which is already discussed in the sale chapter. Okay. So, it is all about the law of exchange. Okay. So, just I will summarize now within 2 minutes. That definition we have seen, that for movable or immovable, there is a transfer of ownership, okay, and money will be not the consideration. Money will be consideration, then it will go under the sale. So, it is a mutual transfer of ownership for movable or immovable things, okay, without money consideration. Then oral exchange is not allowed, only written instruments are allowed, written contract is allowed. I have discussed in detail here in this part, that you can just revise it. Movable property, immovable property, written agreement is necessary in all condition. Registration is not necessary in case of movable property. Registration is optional in case of 100 rupees below 100 rupees immovable property, and if immovable property is 100 and above, then registration is compulsory, but instrument is compulsory in all cases. Then characteristic feature, that is deed of exchange must be a valid contract. Okay. I have discussed through case laws. Then party deprived right will be like that, there are 3 rights of the deprived party. Okay. What are those? These rights are that B will deprived party will have a right to for compensation and to return back the property. Return back property is only allowed in 3 conditions. First, where the property is in possession of other party, or property in possession of the other party legal representative, or other party has already transfer without consideration to the third party. In these cases, 3 cases, deprived party will have remedy. Okay. And then all rights and liabilities like seller and buyer will be with the exchanger. Okay. So, in that way it is this rights and liabilities is just like that. I have already discussed the seller and buyer. Okay. Then exchange of money, it says that exchange of money transferred must be genuine, and money given must not be counterfeit or fake money. This is, but only the transfer of money will not fall under the category of exchange, but it has been said exchange of money is possible, and these are the things, because money is not a consideration at all. Okay. So, this is all about law of exchange under Transfer of Property Act, and in that way there is a completion of this course within 20 lectures. Thanks.